If your long-term disability claim is denied, there is one mistake that can quietly end your case before it ever begins. It's called the one-line appeal letter. Hi, I'm Brandon Osterbind, and I'm a disability lawyer here in Virginia. And before I get into today's video, if you find these videos helpful, please take a minute and subscribe to our channel and like this video. Now, I want to talk to you today about why sending a one-sentence appeal, I appeal, period, is one of the most dangerous things you can do. And this is an update to a video that we recorded back in 2021, not because the concept is new, it isn't, but because the rules around what a proper appeal is supposed to look like and what you're entitled to do during appeal are now clearer than ever. Now, here's how this usually happens. You apply for long-term disability benefits through your employer's plan. You submit medical records. You do what you're told, and then a denial letter shows up. After that, someone from the insurance company calls and says something that sounds helpful. They say, you have the right to an appeal. And if you just send us a short note saying that you appeal, we'll review it again. That sounds reasonable, actually, but until you understand what's actually happening. Because when they deny you, the insurance company is saying, based on what's in our file right now, you don't qualify. So if you appeal with one sentence, you haven't changed their file at all. There's no new medical opinions, no clarifications, no functional testing, no vocational proof, no correction to their factual mistakes. So their review becomes the second pass through the same record, and the denial becomes permanent. Under ERISA, that's a huge problem, because ERISA appeals aren't just a courtesy. They're governed by federal rules that require a full and fair review. Let me read to you a piece of that rule, because this is a part almost nobody is told. The ERISA Claims Procedure Regulation says that your appeal must provide claimants with the opportunity to submit written comments, documents, records, and other information. It also says the plan must provide for a review that takes into account all comments, documents, records, etc. Now let's break down what that means in real life. First, the appeal is your chance to build the file. The rule isn't saying send one sentence so we can rubber stamp the denial. It's saying you get the opportunity to submit things that actually prove your disability in writing in the record. So if the denial says your records don't support restrictions, then the appeal needs restrictions supported by a doctor. If the denial says you can do sedentary work, then the appeal needs functional proof and job duty proof that you can't do what they say you can do. If the denial says you can do sedentary work, then the appeal needs functional proof and job duty proof that you can't do what you can't do. If the denial says your symptoms are subjective, then the appeal needs objective support where possible and consistent documentation of subjective symptoms and how they affect your function. A one-line appeal letter does none of that. Second, they have to consider what you submit, but only if you submit it. The regulation requires them to consider all the materials you provide on appeal. But if you submit nothing new, there's nothing meaningful to consider. So the denial stays exactly where it is. Third, you are entitled to see the relevant material in the file. The regulation also includes a major protection that most people don't use. It requires that the claimant be provided on request and free of charge access to relevant documents in the claim file. That matters because you can't write a strong appeal if you don't know what they relied on. Sometimes a denial is driven by a nurse reviewer or a paper review doctor or selective reading of medical records or cherry-picked notes that don't reflect the full picture. If you don't request the whole claim file, you're appealing blind. Fourth, disability claims have an added procedural protection, and for most disability claims, the Department of Labor has strengthened these procedures to improve fairness in how disability claims are handled. The practical takeaway is simple. A real appeal is not simply, I disagree. A real appeal is a legal and medical record building process. So here's a rule of thumb that I want you to remember. If you send a one-line appeal letter, you're basically telling the insurance company, please deny me again, because nothing has changed. And under ERISA, the appeal record is often the same record that the judge reviews later, not your live testimony, not your day-to-day story, not what you meant to say or what you meant to submit. It doesn't include any of that. So what should you do instead? A proper ERISA appeal has two jobs. Job number one, it'll add new evidence that answers their reasons for the denial. That can include updated medical records, a detailed treating provider narrative, functional capacity testing when that's appropriate, a vocational opinion tied to your actual job duties by a vocational expert, or statements from people who see your functional decline day to day. Job number two is to explain exactly how their denial is wrong. Not emotionally, not generally, specifically. Where did they misread the medical records? What job duties in your job description did they ignore? What policy definition did they misapply? What medical opinions did they dismiss without explanation? That is what moves a claim. I hope all of this information has been super helpful for you. And if so, could you do me a favor and just take a second to subscribe to our channel and like this video? And if you like this video, I'm sure that the next video, when should you file for long-term disability benefits, will be just as helpful, as it breaks down the real timeline that should be followed when considering long-term disability benefits. If your claim has been denied and you're thinking about appealing, don't send a one-liner. Get advice from a good ERISA lawyer first, because in ERISA, the appeal is often your best chance to win your case. Just give us a call.